The Constitution, through the Fourth Modification, protects folks from unreasonable searches and seizures by the government. The Fourth Modification, however, isn't a guarantee against all searches and seizures, however solely people whose square measure deemed unreasonable beneath the law. Whether a specific form of search is taken into account affordable within the eyes of the law, is decided by equalization to necessary interests. On one aspect of the dimensions is that the intrusion on a person's fourth modification rights. On the opposite aspect of the dimensions square measure legitimate government interests, like public safety. The extent to that a personal is protected by the fourth modification depends, in part, on the situation of the search or seizure. Minnesota v. Carter, 525 U.S. 83, 1998. Home searches and seizures within a home while not a warrant square measure presumably unreasonable. Payton v. New York, 445 U.S. 573, 1980. However, there square measure some exceptions. A warrantless search could also be lawful. If a political candidate is given consent to search, Davis v. U.S. 328 U.S. 582, 1946, if the search is incident to a lawful arrest, U.S. v. Robinson, 414 U.S. 218, 1973, if there's evidence to look and exigent circumstances. Payton v. New York, 445 U.S. 573, 1980, if the thing's square measure in plain view. Maryland v. Macon, 472 U.S. 463, 1985. A person when a political candidate observes uncommon conduct that leads him fairly to conclude that criminal activity could also be afoot, the officer could in short stop the suspicious person and build affordable inquiries geared toward confirming or dispelling the officer's suspicions. Terry v. Ohio, 392 U.S. 1, 1968. Minnesota v. Dickerson, 508 U.S. 366, 1993. School officers needn't acquire a warrant before looking out a student. Who is beneath their authority, rather, a hunt of a student would like solely be affordable beneath all the circumstances. New Jersey v. TLO, 469 U.S. 325, 1985. Cars where there's evidence to believe that a vehicle contains proof of a criminal activity, a political candidate could lawfully search any space of the vehicle within which the proof may be found. Arizona v. Gant, 129 South Court. 1710, 2009. An officer could conduct a traffic stop if he has affordable suspicion that a traffic violation has occurred or that criminal activity is afoot. Berrickma v. McCarty, 468 U.S. 420, 1984, United States v. Arvizu, 534 U.S. 266, 2002. An officer could conduct a pat-down of the motive force and passengers throughout a lawful traffic stop. The police needn't believe that any dweller of the vehicle is concerned during a criminal activity. Arizona v. Johnson, 555 U.S. 323, 2009. The use of a narcotics detection dog to run round the exterior of an automobile subject to a sound traffic stop doesn't need affordable, explicable suspicion. Illinois v. Cabales, 543 U.S. 405, 2005. Special enforcement issues can generally justify main road stops with non-personalized suspicion. Illinois v. Lidster, 540 U.S. 419, 2004. An officer at a global border could conduct routine stops and searches. United States v. Montoya de Hernandez, 473 U.S. 531, 1985. A state could use main road sobriety checkpoints for the aim of combating drunk driving. Michigan Department of State Police v. Sitz, 496 U.S. 444, 1990. A state could came upon main road checkpoints wherever the stops square measure temporary and get voluntary cooperation within the investigation of a recent crime that has occurred there on main road. Illinois v. Lidster, 540 U.S. 419, 2004. However, a state might not use a main road stop program whose primary purpose is that the discovery and interdiction of criminal narcotics. City of State Capital v. Edmond, 531 U.S. 32, 2000.